My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk about proposed drafts or leaked drafts of new immigration executive orders. According to American Immigration Lawyers Association, President Trump and his administration are planning to release 2 more executive orders regarding immigration. The drafts were made available by unknown sources and distributed amongst media and legal community, and I would like to address concerns and information that is contained in those drafts. Drafts are dated February 17th, 2017, so if those drafts will be finalized and will be released, we're going to be dealing with the following priorities that are set up in those executive orders. Well, first of all, I made some notes because each draft is about 6 pages. First of all, the drafts say that all immigration enforcement officers should concentrate their attention on the following groups of inadmissible or deportable immigrants. Those are immigrants who are inadmissible based on criminal and related grounds, on security grounds, on the grounds for fraud and on misrepresentation. Also, those who are deportable because of the criminal convictions and security grounds, deportable removal based on the fact that people are subject to expedited removal. And one of the drafts basically expanding the category for expedited removal. What is expedited removal? Expedited removal is a type of proceedings when the person who is being deported or removed out of the United States does not have a right to see the judge. So it's very fast proceedings where the person cannot present, even if he has or she has any defenses to the removability. So you will not have an opportunity to see a judge or stay in the United States while the proceedings are pending. And one of the proposed orders are expanding this category. What does it mean expanding? Well, until recently, only those who are being not let into the country at the border or apprehended at the border before they entered the country, or apprehended, taken into custody by ICE within 100 miles from the border, and as long as the person has been in the United States for less than 14 days, only those people were subject to expedited removal. Basically, you're being arrested, the officer questions you if you have any grounds to stay in the United States, and how long you've been in the United States, if you're in the United States, and the only defense or only opportunity for you to stay in the United States under the circumstances if a person is applying for asylum and asks for asylum. Relatives in the United States, possibility of employment in the United States are not grounds for defense. Unlike in regular proceedings, if you were or a person was placed in so-called expedited removal. So one of the orders is expanding categories of people who can be subject to this expedited removal proceedings. And now the order says that all those who do not have basis to stay in the United States, basically who entered without inspection and who cannot show that they have been in the United States for 2 years at the time when they're being questioned. So basically the person has to show that he has been or she has been in the United States for at least 2 years at the time the person is detained. Such people will be also subject to expedited removal. They will no longer be placed what's called 240 proceedings, removal under proceedings under Immigration Nationality Act, Section 240. They will be placed in the proceedings under Immigration Nationality Act 235. This is an expedited removal. And under this section, you cannot ask for many forms of relief, unlike for 240 section. So this is a drastic change. The administration says that with that, they're trying to unburden the courts, immigration courts that are very clogged, and there are many delays. But I'm not sure if this is the right way to do that. The also orders addresses another very interesting new measure. It's basically, if I understood it correctly, let's say somebody was apprehended at the border because the person is trying to enter the United States, surrenders themselves at the border asking for asylum. Previously, if a person passes credible fear interview, the person was allowed to come into the United States, the person will be paroled, and then the person will be placed on the 240 proceedings, which will allow the person to apply for asylum. Now what they're proposing, or they're ordering, I guess, is that the person will not be allowed into the United States. The person will be detained and returned back to the country the person came from while the proceedings under Section 235 or 240 are being held. So basically, the possibility of parole or being let into the United States while a person is applying for asylum is going to be very limited. That's how I understood the order. But again, it's a draft, and I just read it today, so I'm not sure that what's going to happen. But I believe that the text of the order says that basically that no more allowing everyone coming in and surrender at the border, but that opportunity will be provided to a very selected group of people. The order explains extensively under which circumstances somebody can be paroled in, that the officers have to exercise discretion. There will be no more groups of people who are excluded from possible removal while we're talking about prosecutorial discretion, but rather everything is going to happen on a case-by-case basis. The good news is that the order reaffirms that when we're dealing with the prosecutorial discretion, executive orders that are protecting DACA beneficiaries or DACA eligible people will still be in effect as long as order that is protecting parents of the United States citizens, lawful permanent residents, that order about prosecutorial discretion is still going to be in effect. But the order, the memo, dated to November 2014, is no longer in effect. That memo established classes of groups of people that were not priorities for removal. So that memo is no longer in effect. What's going to be in effect is the new regulation that was first announced in January of 2017, and now there is a draft of a more detailed regulation that basically says that all those who have who've been convicted of a crime, who've been charged with a crime, even if the charges will not result in a conviction, those who abuse public benefit system, those who have outstanding orders of deportation, those who are suspected of immigration fraud, all those people are now a priority for removal. And if they would like to apply for relief, like a prosecutorial discretion, there will be determination made on a case-by-case basis. I would say that without sufficient guidelines. I'm not sure what case-by-case basis means, because before we had guidelines, criteria that we would look at and we'll say, yes, this person had lengthy stay in the United States, has had family ties and things like that, and now we're really not sure what we're going to be looking at, but maybe it will be clarified. but that's where we stand right now. It means that basically anybody who entered the United States without inspection recently, within the past 2 years, anybody who had old order of removal, even if an order was done without the person, sometimes people don't know that they have an order of removal. All those people are now a priority. Another very important thing that's been discussed in these orders is that previously ICE was like, ICE is an immigration police. ICE people are those people who are arresting and detaining people who are suspected of immigration violations. Now the order proposes to contract local law enforcement, state law enforcement officers to help with apprehension, detention, and removal of the immigrants. And under the order, the way it's supposed to work is that the federal government is going to have contracts with local law enforcement that will give them power to carry out immigration law enforcement functions. That's at least this information that I'm giving you right now is based on the proposed or leaked immigration executive orders. I'm not sure if those are the final versions. Maybe there will be modifications. I'm not really sure if everything that's said there is going to happen, but that's where we stand right now. I will publish on my website those drafts, so anybody who's interested can read them for themselves. So basically the bottom line of all of this is that anybody who has any type of immigration violations now can be a target, especially those people who were charged with criminal acts, even if if those charges are erroneous. It seems there is no distinction now between being convicted and being charged. So technically, if you would like to remove somebody, you can just charge them, and now they're priority for removal. So if you'd like to, if you have questions, you're always welcome to ask those questions through our website, www.shautsova.com, or you can submit your questions through our Facebook page, New York Immigration Lawyer. And I will always be happy to answer simple questions for free, or at least guide you in the directions that you need to go, you need to head to do your further research. Thank you very much.